Good morning, everybody. Lovely to be here today to talk about contracts and new starts. It's a topic very close to my heart. I could sit here and talk to you for about 5 hours, so I'm conscious you probably don't have that long. So I've had to consolidate a lot of information to try and fit it all in today. So I am going to be speaking quite quickly, and I do appreciate there'll be some topics that are more relevant to certain people. But if you do have content that isn't clear, do ask questions. If I can answer them today, that's great. If we have not enough time, I can come back to them and we can discuss later at another point via email or something. So thank you for your patience. So next slide, please. So I'm going to take you through hopefully all of this content if I have enough time. There's a few slides that are interactive, depending on the time we have, will depend on how much interaction we have as well. So let's go through those points today. I won't dwell on that slide, thank you. So before I even begin to talk about this, can I just ask you with a show of hands, so if you look in your reaction button on the bottom template bar, you can react with a show of hands. I want to know, first of all, who currently has contracts in place for their employees or for themselves. If you do, just give me a hand up or a thumb or smiley face, just so I can see who currently has contracts. There's quite a few of you who do. That's great. Lovely. Thank you. And can I ask a separate question, if you can unreact for that moment? Who doesn't have anything in place contractually for themselves or for their directors or for their employees? And I'm not going to penalise anybody here. It's not a problem if you don't have anything in place. Okay, good to see. Fabulous. Thank you. Okay, so I'll go into the legal requirements of providing contracts shortly. But what I do on a daily basis at Atoll HR is work with clients. Typically, they come to me with problems. They come to me when somebody's not performing, or they come to me when they've got an issue and how to manage somebody. And my first port of call every single time, without fail, is what does the contract say? So I can't stress enough how important it is to have a piece of paper with a few words on it to cover how you're going to manage certain situations. I'm constantly asking that question, what does the contract say? And the person I'm dealing with, the client, will say, well, the contract was put in place, oh gosh, 7 years ago, which is fine. Some of it is still relevant. But as we all know, law changes, legal updates come out. The last legal update with contracts was 2020. So if you've not addressed your contracts since 2020, you've possibly got some out-of-date clauses. So they do become out of date. People may have documents full of lots of lovely information. I also see contracts that are 50 pages long, written by lawyers, and we work with lawyers where we have a lot of support from our legal team. But again, some of those contracts are far too wordy, and not only do you as employees not understand what it means, your employees struggle to interpret some of those clauses. Some of my clients add clauses when legal updates come into play without realizing that they're then contradicting various clauses within that contract. I've seen contracts that state notice periods in the starting sort of page of the contract, yet later in the termination requirements, the termination or the notice periods are completely different. So it's really important to look at your contracts holistically without just adding and taking bits off the shelf or off Google or those lovely resources we all have access to these days. I also see contracts that are completely irrelevant for the individual, and we'll go into the different types of contracts. But often employers have a contract which has been written by a good resource, and they will use that for every different scenario. So they might have somebody working for a short period. They might have somebody working sporadic hours, a Saturday here, a Monday there. They might have somebody working on reduced hours, and they're adapting or trying to adapt that contract for each of those scenarios, and it doesn't work. It doesn't work. So it's important that you bespoke your contracts for the scenario that you want to use with that employment situation. Also have changes to contracts. So people are unsure about how to, they might have one standard contract, yet they don't know how to change it for somebody who might want to work flexibly. What does that look like now? And is it a problem having one person only on a unique contract whilst everybody else is on the old contract? How does that happen? Do you have to change it for everybody? So there's some really good questions that I get faced with on a regular basis that hopefully by me going through the content today will iron out some of those questions. Okay, if we move to the next slide, you're probably all familiar with this. I'm going to whiz through this. Obviously, legally, there are employment rights that are passed via Parliament on a regular basis, and you can see those there: right to minimum wage, right to not be unfairly dismissed, which kicks in after 2 years, right to statutory redundancy pay, again after 2 years, right not to suffer any unauthorised deductions from wages, right not to be discriminated against, right for flexible working, which is a more recent request, maternity, paternity, and protection against any unfair treatment for whistleblowing or trade union activity. So there's lots of statutory rights that go without saying in terms of protection for employees in the workplace. They are there, they can be included in contracts, but typically they're not. What is typically included in a contract is on my next slide, please, is contractual rights. So you're then going to probably, on the back of those statutory rights, be a bit more specific for your situation with your employees. So probationary periods, you might specify a certain period, depending on how long you wish to be able to observe, train, develop that person. Notice periods, again, will be different for every business. Salary and bonus clauses will be included in contracts typically. Benefits, holidays, sick pay, training, restrictive covenants, all these things my clients typically bespoke for their specific needs. And that's exactly what I would expect to see. If we can just pop to the next slide, please. So my first question to you guys today is, does a job offer have to be given in writing? Now, if you believe it does a job offer have to be given in writing? Could you raise your hand? There's no right or wrong answers. Well, there is, but I'm not going to hold it against you. If you feel a job offer has to be given in writing, please raise your hand now. Okay, I can't see any hands. One hand, a couple of hands, here we go. Oh, what does she mean? Okay, thank you. So the answer, there's two answers to everything, isn't there, depending on what kind of question you're asking, but I mean, a job offer in its verbal essence, when you speak to somebody, is a legally binding agreement. So if you offer somebody over the telephone and say, I'd like to offer you a sales associate position starting 1st of October with a salary of 25k, that is a verbal legal binding agreement, and it is contractually going to be upheld if you're challenged on that. Obviously, most people don't just do that. They then need to back it up with something in writing. And the law tells us we have to issue principal statements on or before their first day to cover specific details. And I'll go into that shortly. So be careful that whatever you do, and the reason I'm saying this, we've got clients that have offered verbally, not followed up, and then been held to ransom against those verbal offers. So whatever you give in offer, on a telephone call or a Zoom call, just be careful, because that is a legally binding agreement. Equally, can I ask the question, with your offers and with your contracts and letters, who here currently gives unconditional offers? Give me a question. And what I mean by that is there are no terms associated with that offer. So you're giving an offer, I'd like you to join today, tomorrow, next week, and salary is A, B, C, blah, 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 with no conditions. Who offers in that light? Hands up if you do. And again, it's not a problem if you do. Okay, a couple of people. Good. Okay, so unconditional versus conditional. I always say, think about things that are essential to you as a business. So if you need somebody to have a certain qualification that you need to check up on that they have, obviously you might get somebody come in, paperwork, etc. It might take a while to do DBS checks or qualification checks. It might take a while to do reference checks. So I would always encourage businesses to make the offers conditional, dependent on those checks that you need to take, because once you make that verbal written offer and you've not included any conditions, your offer is on the table, and you can retract an offer. It depends on whether the employee has started working. Once an employee walks in the door and clocks on for 1 minute of time, they are bound by statutory rights. So if you've no conditions associated with that offer, it's very hard to retract. So do think about that when you're making offers as well. I'm talking lots of legal terms here, so I do apologise if I'm confusing, but please do ask questions as we go. Okay, so if we move to the next slide, we've talked a little bit about documentation, but what do you have to legally issue? This changed, I think it was 2020, that the written statement of employment particulars has to be issued on or before the first day of employment. So you need to be giving a document. It doesn't have to be a fully fledged contract, but it has to include those specific details that you can see on the slide: personal details, start date, etc., etc. And even I'll highlight the points at the back of that paragraph. Training requirements, which became a new legal requirement in 2020. If you are requiring them to attend specific training for your business, you need to tell them upfront what that is. And also any paid benefits, not just holiday, any enhanced sick pay, but any benefits you're offering must be included on or before the first day of employment. You then have the obligation to issue them with a wider statement, and this typically looks in the shape of a contract, which includes the other points mentioned there: pension information, any collective agreements with trade unions, any disciplinary grievance procedures, etc. And that has to be issued within 2 months of joining. Typically, we encourage people to do an offer letter and a contract covering all of those elements before the first day. I mean, I know if it was me being offered a contract, I'd want to see all of it prior to accepting an offer. So best practice would suggest you do that prior to somebody joining. Okay, so let's move on. The benefits of issuing a contract, these go without saying, but it's important to stress, if you're trying to attract employees in this very tough candidate market, and for any people who've recently recruited or who are involved in recruitment, it is a very, very tough market, particularly in certain industries. So having a good structure to your contracts and your letters of offer demonstrates that professionalism. It demonstrates you know how you're managing your employees. You have certain standards, you have various policies in place which are referenced in the contracts. It gives you a good edge. Importantly, it also reduces the risk. And when I say risk, I'm talking about any issues in relation to if you need to retract or withdraw or take away monies at any point in time. You've reduced any risk or exposure to your business if somebody happens to borrow money or take out a loan or takes excess holiday, etc. You've got the ability to do that. It also gives certainty in relation to what the employee can expect, because it's all good and well when employment begins and it's a lovely relationship and everyone's happy, but if things were to go wrong, and unfortunately people are unpredictable beasts, things do get quite uncomfortable if things aren't written down. So if you've got reference to a notice period, or if you've got reference to how an employee should be managed in terms of absence, or they understand what restrictions are going to be imposed upon them if they choose to leave, people are in the full picture, and that certainty is important for certain actions if they choose to take them. it also regulates behaviour. I encourage employers to include sort of codes of conduct, if you like, or certain points in a contract which encourages good behaviour. So, you know, points like follow management instructions, behave in the best interests of the company. Those sorts of generic clauses, if you are ever faced with disciplining somebody down the line and you have those clauses in place, you are able to then state or claim that the employee may be in breach of some of those contract terms, you know, trust, etc. So including behavioural clauses is a good thing. I mean, you will also have policies, I'm sure, that back up, such as code of conduct, etc., which, you know, which highlight these behaviours further. But if they're in the contract and somebody behaves in a way that goes against those clauses, then they are in breach of contract, and you are in a much better position to deal with them because they've gone against something which they're contractually obliged to follow. And the biggie here is post-termination protection. I see lots of restrictive covenants in contracts, which is great, but I equally see lots of terribly written covenants, which are very broad, very vague, you know, restricting somebody to work in that industry for a whole year. That would never stand up. You can't do that to somebody. You have a right to work, and that completely goes against the statutory right to work. So some of those clauses need to be addressed because they just wouldn't stand up. Cons of issuing a contract is obviously that it's legally binding. So if you do have something in place in the contract and you don't follow it, you're yourself in breach of that contract. You have to follow what is written. So be very clever, careful when you're writing those clauses, and work with somebody who can write them exactly how you need them. Sometimes putting too much in a contract goes against you, because if you don't follow it, then you're exposing yourself potentially being in breach. But we can help wording those clauses so that they do protect you. Equally, it may limit flexibility, although if your contracts are worded correctly, you shouldn't find this. But the bottom one is a biggie: consulting to change. To make any change to any of the clauses in that contract, you would have to consult. And the rules of consulting will vary depending on the numbers of people affected by that change. So if you have in place at the moment, you've got everybody working from the office in Bristol, however you now will work from home, you probably should change your contracts. Doesn't mean you have to. You could do a contract addendum just to make a subtle change to that. But if there is something which is going to be detrimental to an employee because of that change, you should definitely consult. So there are rules around consultation. Okay, next slide, please. So a couple of points here. I'm going to ask a question again and again, if you could raise your hand, if that's okay. So each of these clauses in the last year, I've had a client that have had issues with. Okay, so I wanted to raise this just for your own information, just to help you, because it may be something that you're currently facing. So first of all, who has contracts, and of those people who have contracts, do you have a probation period in your contracts? Just raise your hand if you do, please. Okay, so I think most people do include probation periods, which is good to see. So a probation period, thank you everybody for commenting. A probation period is important, and I do see contracts that don't have them, and then people try and terminate early, which, if there's no probation period which tells the employee that you can terminate early, you're again facing potential breaches. But probation periods are good for both parties. Some people put in place probation periods for 3 months, 6 months. I do see even longer, which concerns me. But this is the time when you're supposed to be developing training, giving as much information to the person if possible. There is an implied right to work. So if you just suddenly terminate somebody's probation period without notice, which you can legally do, you may be infringing on their right to work. I would always encourage best practice, and I'm sure ACAS is supportive of this, if you are considering terminating in probation periods, to give notice first. Because again, think about, what is the right way of managing somebody? Would you like to be terminated without notice? You'd like someone to tell you that you're failing in a certain area. So I would always encourage people to have a conversation prior to termination of that probation period as best practice. I also see lots of employers getting to the day before the end of the probation period and suddenly going into a panic because they haven't addressed anything. And then maybe just going out and saying, right, that's it, it's the end of the road, thanks for your time, goodbye. So diarise first month, second month, final month, a conversation, a one-to-one, even if it's a, look, how's it going for you? Here's some feedback from me. But whatever you do, do not go past the date of that expiry, because once you go past the date of expiry, probation is over and you can't go back. And yes, they're not entitled to any unfair dismissal rights until 2 years of service, but you are potentially still facing discrimination clauses, because anybody can raise a discrimination claim at any period within their employment. And if the person in question feels that they have been unfairly treated, perhaps because of their age, because of their gender, etc., they can take a claim for discrimination against you. So do watch your probationary periods. Working location. This is a really interesting one, because obviously most of us have changed our working location. And we had a case recently where we had an employee, a manager, who was whose contracts said that their contracts were actually quite ahead of the time and said that they were working from home. So this chap decided to go and work in Switzerland. Well, actually, he did actually ask permission to go and work in Switzerland. His manager, his director said, no, sorry, I need you to be in the UK. You manage people, you need to be available. He then decided to just go and work from Switzerland anyway. So he left. And the director asked him to come into the office from time to time. This case went to a significant point where there was disciplinary action. He was terminated. He raised a grievance, went to ACAS, etc. And the outcome here is that his working location, whilst it was specified as home in his contract, because his practice prior to this period was occasionally coming to the office, the implied term was that he did need to come to the office to manage his staff occasionally. And when we went through his clocking on history, we managed to find 16 incidents within the last 6 months of him coming to the office. So whilst the contract clause stated it is home as the location, the pattern, which was not in the contract, but his pattern of employment, suggested that it was also working in the office. So we were okay to carry on in that vein. So check your working location clauses. I would always encourage now words to the effect of working from home and from other locations from time to time, or something along those lines to cover yourselves. Mobility clauses. Again, working beyond the UK, staying in the UK, just check how you've written those clauses, because if you ask somebody to go overseas and you haven't got that in their contract, they can refuse because it is not contractually reasonable. You may also wish to back that up with a relocation policy. Withholding monies is another biggie. If you're trying to, when someone leaves, you're trying to take monies back, whether it be any outstanding loans or training course payments that they perhaps need to repay. If you have not got that clause in your contract, you're going to find it very difficult to try to retract any monies at that stage. Holidays, a question I'm often asked: should you include the actual number of bank holidays, or should you keep it fairly broad and just refer to holidays? And the case, particularly this year, was with the additional holidays that we were granted because of the Jubilee celebrations. So my clients came to me and said, oh, I've got holidays that state I'm entitled, or that my employees are entitled to 20 days plus 8 days bank holidays. So for those individuals who had that in their contracts, they weren't entitled to any additional bank holidays because their contract stated no, they weren't. Now, I found that really harsh because everybody across the country was taking time off and so on. But depending on how that clause was written would potentially mean you could ask somebody to come to the office. Again, best practice suggested that it was probably better for well-being and so on to award those additional days, but contractually, legally, they didn't have to. Bonuses. Who includes bonuses in their contracts? Bonus clauses. Hands up. A couple people. Okay. So bonuses are an interesting one because contractually, I would suggest not to include specific details around bonus payments, because if you want to make any changes to those details, you are going to have to consult to change because it's contractually binding. You can certainly reference bonus payments in a contract. So bonuses may be paid from time to time. A bonus may be an individual bonus, or it might be a group bonus. You can go into that type of detail, but I would certainly encourage any specifics around bonus, i.e. you're going to be entitled to 5% of earnings or whatever, to be completely excluded from a contract so that you can change it. You can bring in an additional appendix or a schedule which says the bonus for 2022 is ABC, and therefore you're not required to make actual changes to a contract if those bonuses change. And a caution on bonuses, again, a case in points, group versus individual. Be careful how you word it, because if you word it as a group or a company bonus and one individual gets the bonus, a company or group bonus therefore should be issued and awarded to everybody because it is categorized as a group or individual bonus. And if you try and say, well, actually, that person didn't pull their weight. No, a group company bonus is based on everybody receiving it. I've seen case law where people have been paid in retrospect because they were entitled to a group or holiday company bonus. Pylons, so payment in lieu of notice clauses. Again, if you're wanting to do this, pay someone in lieu of notice when they terminate contract. You can't do so unless you have that actual clause specified, so make sure you put those in. Notice periods, I've already covered that. You cannot unilaterally extend, shorten, or take away notice periods without consultation. An individual might come to you and say, look, I've handed in my notice. I want to finish this Friday. I know I've got to give 4 weeks, but is that okay? You can approve that. They are breaching the contract, which is fine because they're choosing to do that. But in essence, it's totally your call. You don't have to. You certainly can't do that if that clause isn't in there, because you could face action if you choose to go down that path. Garden leave, again, another clause which must be included if you're wishing to put somebody on garden leave. And this is talking about how an individual must behave in those last few weeks of employment. Should they be available at all times? Should they have access to systems, etc.? You should identify and specify those particular restrictions. And suspension, if you don't have a suspension clause, you're unable to suspend somebody if you need to take any investigatory action. So suspension clauses are also really, really important. Alrighty, sorry, I am going on a lot here, and it's probably very dry for you. I love it, but it's please bear with me. Important stuff. Okay, so let's move on to the next slide. Now this is, we're starting to get to some really nitty-gritty stuff here, which I think is important when you're creating your contracts. As I've said already, it's an agreement between an employer and employee. Written or verbal, we've covered that one already. Express or implied. Now, an express clause is a clause that is written down, and it is, I've already covered some of those: a restrictive covenant, a notice period, holiday entitlement. It's written in black and white very clearly in your contract. An implied term is a clause or a statement which is presumed to be understood, and it's usually around conduct and behaviour. So we've sacked a guy before, whereby, crazy scenario, it was a Christmas party, those good old Christmas parties, and he decided to, I won't go into the detail, thankfully, but he decided to become undressed and go and join another employee in a awkward position. Let's just say that. We took him into a disciplinary, and he claimed that he could behave in that manner because it wasn't written in his contract or in the code of conduct that he couldn't get naked. Seriously. Now, thankfully, an implied term is something which you wouldn't specify. You must not undress in front of your colleagues. You don't need to specify that, but it goes without saying. It's part of the behaviours that I mentioned earlier, whereby you need to behave in a way that is, trusting, mutual respect of your colleagues, etc. So we threw him out with that one, and he was sacked, obviously. But an implied term also covers things like, I didn't know I couldn't come to work with alcohol on my breath. Okay, well, it's not written in your contract, but we would expect that if you're smelling of alcohol, there is, potential issues. You could still be under the influence. You could still have a high level of alcohol in your system, which, particularly if you're operating machinery, driving, is clearly unacceptable. So there is those sorts of behaviours that, again, if somebody says, well, it's not written in my contract, it's not written in the code of conduct, there's no policy on this, it's an implied term. You expect somebody to come to work, ready to work, to be trusted to follow instruction in an appropriate manner. And these are the behaviours I was talking about earlier that I would encourage you to include in your contracts, so that if you do get somebody like the people I've just described, you can tell them it's covered in those behavioural clauses. So express and implied terms. And my advice is, if you want something specifically to be very clear in a contract, then make it an express term. Put it in as a clause. If you do have issues with people turning up drunk, bring in an alcohol policy. Put in a clause about what that would look like if somebody, maybe some of the examples of gross misconduct, being having alcohol in your system when you arrive at work, something along those lines. So you may need some express clauses, particularly if your industry that is important. So think about those and make them express so that you're covering yourselves. Okay, let's move on to the next slide, please. So if I've bored you completely already, I apologise, but this is the time to listen. If at any stage you want to really pay attention now, please listen. So there is a contract test. There's been so much case law recently around whether somebody is to be deemed as an employee, or whether they're self-employed, or whether they're a worker. And this is the test that you should always apply when you are trying to determine if somebody is in fact entitled to statutory employment rights. So the first element of this contract test is whether the individual provides an individual service, a personal service to your business. So if you are employing somebody that has a particular skill set, or has a particular reputation, or brings something to the table that you specifically need them to turn up and do every day, as opposed to somebody else who does their job, then that person is deemed to be ticking the box of they are providing a personal service. So the obvious one here is if you're employing somebody to come in and deliver training, and they're sick one day, and then they send in a substitute of another trainer to come in and deliver the training. That isn't providing an individual personal service. You can take on board anybody. Your employees typically would be deemed to be providing that personal service, and that's the first test. The second test is the mutuality of obligation. So the employer under their contract is required to provide the individual with work and a set of tasks via a job description, etc. That is the obligation of the employer. Equally, the individual is obliged to do that work in return for monies, for payment, for benefits, etc. So there is a mutual obligation in your relationship. The third element to this test is probably one of the big ones. So control. Who has the control? So when you're employing somebody to come in as an external person, I might be coming in to run a training course. You might say to me, can you run a training course on employment contracts? You're not going to say to me, you might give me like an outline and you might give me some guidelines, but as a self-employed person, I might come along and do a lot of my own thing. I have the control to include the content. I can turn up and use my own computer. I might be deciding the duration of the course, etc. The control over somebody and what they are required to do is a big test about who has control, who is the ultimate person making the decision, and therefore, is this person self-employed? Is this person a worker or an employee? Now, these three tests don't operate in isolation. When you're looking at somebody working for you, and I'm talking here about people who you typically use as self-employed people. So if you have any workers that come along, do a little bit of work, a bookkeeper, for instance, come along, do a bit of work, and maybe 3 days a week, off they go, come back next week, 3 days a week, off they go. They're employed on a self-employed basis. However, if that bookkeeper is only the person doing that particular task for you, and responding to you telling them, well, you have to come in Monday, Tuesday, Wednesday, you have to work 7.5 hours a day, you have to use my equipment, and also I will tell you which clients to work with. The control is suddenly shifting to be in the lap of the employer, not in the lap of the bookkeeper. We're suddenly merging into a very grey area here about, should this person actually be employed as a part-time bookkeeper, as a casual bookkeeper, maybe a 0 hours bookkeeper, instead of the self-employed bookkeeper that you've currently got on your books. And this is the crux that I'm talking about. You may have people working for you that you're unsure, are they self-employed, really in the true sense of the word, or are they employed? Now, what's the worst that can go wrong? HMRC can get wind that you're employing somebody, you're not giving them employment, statutory employment rights, you're not allowing them to receive holiday, etc., and therefore you are failing to meet your NI tax obligations, and you can face fairly significant fines. You might say, well, hang on, this bookkeeper doesn't want to become an employee. Fair enough, but you need to change that relationship the way they're working, because at the moment they are very much working as an employed individual. The classic test, you remember back in, I think it was 2020, maybe even before then, 2019, was Uber. So Uber workers, self-employed taxi drivers, who claimed that they should have been entitled to employment, statutory employment rights to holiday, rights to time off, etc. And Uber said, no, these guys are all self-employed, they drive their own taxis, we have no control over them, and they are self-employed, leave it be. This case was scrutinised very much in the press, which I'm sure most of you would remember. And it turns out that in terms of the three tests I've talked about here, it was the drivers had no or very little control, because first of all, they were interviewed and selected via a selection process. So the employer had the control over who was going to work for Uber. They controlled what fare that the taxi drivers would charge. They controlled the duration of the trips, who they were allowed to pick up and not pick up. That was all set via a system beyond the control of that individual worker. They weren't able to negotiate a higher fare. They couldn't impose any conditions on trying to get more money. They even made them use certain cars, and they had no control over that. They were also subject to disciplinary procedures. I think they also had performance management on a regular basis. So as you can see, when we look at this test here, they were providing a personal service in that they drove the car themselves, but the rest, you have to turn up at a certain time, you have to do this many shifts a week. The mutual obligation was there, and the control was very much there by Uber. Consequently, Uber lost that case, and these workers now are all classed as workers and are entitled to statutory employment benefits. So if you have anybody that is working for you, and it's usually external staff that come in and do a little bit here and there, have a think about how you contract in with those individuals, because it might be that they need to be on a different type of contract. If we flip to the next slide, you can see here, there's so many types of contract. I've just popped a few on the screen, but some of you may be using some of these. First of all, I will start by saying contract of service is on the left-hand side, and this is typically for your employed people or your workers. And contract for service are those that I've just described, who are self-employed, who might come and do an individual piece of work here and there, but nothing on a permanent sort of fixed basis. Now, if we look at those contracts, a permanent contract is obvious. It's for somebody who you employ pretty much 9 to 5 or whatever your office working hours on a regular basis. And that's the one I usually see most people use. However, given the nature of the way work is currently being conducted, we're now talking about people working evenings, mornings, weekends, and the permanent contract is kind of becoming a little bit old hat. And what I'm seeing is people trying to adapt that permanent contract, which is fine, but they're not adapting it in the right way. So when you are considering your workers and your employed people, it's really important to use the contract that is right for their particular situation. Part-time work, again, it might be somebody who is employed on an ongoing basis, but they're not working full hours. They're working, 17 hours a week, maybe some weekends, whatever. So that's more of a common contract that I'm seeing. A fixed term is usually for somebody who you might need somebody to come and work for a period of 3 months, 6 months. I see people saying, oh, I need somebody to do a project. The project's kind of lingered on a bit now, and it's 2 years, 4 years. That's not a fixed term contract, really. It's becoming a permanent contract. So if you are employing somebody on a fixed term basis, do review end dates. Also review how you end a fixed term contract, because if you don't specify and you want to end it and you try and end it early, or if you say it is until the 31st of December, yet you get to the 30th of November and you're no longer requiring them, be careful and be clear how you articulate that in a fixed term contract. If a fixed term goes over, they're becoming permanent. So do be sure, a bit like your probation period, keep check on your fixed term end dates. Now, this is the one that I find the biggest question. Do I issue a casual? Do I issue a 0 hours? What is the difference? Anybody know the difference? Anybody want to share the difference? Go on, anyone want to speak up? I don't think I would either, to be honest with you. Most people these days just chuck them on a 0 hours contract, because that's, I think, the best way forward, isn't it? They're very, very similar contracts, in all honesty, but a 0 hours contract legally, if you're stipulating in those hours, an employee or a worker has to accept an offer of work. So if your 0 hours contract says, I will contact you every week and give you your schedule for the week, or I will contact you every month and give you your schedule for the month, they have to accept the offer of work. That is the difference. And the reason Uber face the firing line because of 0 hours contracts that they were on, I think originally, is because it's making it very difficult for anybody working on 0 hours to behave, because the nature of casual 0 hours is very much sporadic work, and it's quite harsh to expect somebody to always accept an offer of employment, particularly with the way most of us are working very flexibly these days. So casual contracts I'd much prefer over 0 hours, because casuals can say no to an agreement. So if you say, I'd like you to come in on the first Friday of every month, and that doesn't work for that particular casual, then they can say no to it. Again, you can put clauses in those contracts which say no 3 times and you're out. You can restrict to an extent with those casuals, but it's be careful how you use casual contracts, because again, I see a lot of people not wanting to make somebody permanent because they want to try before they buy, which is absolutely fine. They give them a casual contract. The casual has worked, and I've seen this so many times, the casual has worked for that employer 12, 13 years on a regular basis. That is no longer a casual. Okay, I mean, we're talking go beyond 2 years and we're questioning, is this person, in the true essence of working sporadically, casuals can go for years and years and years. I give you that, but the nature of it should be a casual, sporadic nature. If that casual has worked the same days for the entire time, earning the same salary for the entire time, you've got to question, why is this casual not on a permanent contract or a part-time contract? Okay, so I'm seeing some puzzled faces with casuals. Don't be too alarmed, but just think of the definition of what you want this person to do. It might be that you need a long-term casual, but are they actually casually working for you, or is there an ongoing pattern of employment that they could say, hang on a minute, I'm permanent? And that is the question. Again, happy to take this offline later on if anybody wants to discuss that further. Apprentices, again, very, very different contracts. Apprentices are learning and developing. It's really important that you make sure you allow for that time for development, and you put in place the right type of agreement, whether it be in collaboration with a college, or whether it be just themselves doing some study. But do check if you have apprentices, because they should be on different contracts than normal employees, because they are typically young and typically developing and learning. And you can face various breaches if you do try and terminate an apprentice without having taken into account the fact that they are developing and learning. Directors' agreements. This is one of the biggies, that most people don't have directors' agreements in place, because they usually set up the business with a mate or with a family member with a very good relationship, which is wonderful until it all goes wrong. So directors' agreements are important because they specify, the duties, and it's often around the trust and those behaviours and the expectations of a director that should be included in those contracts. There should also be consideration for shares and shareholding, and how those arrangements are put in place. So typically directors would have articles of association. The articles should be reflected in a director's agreement, and it might be that there's more protection around various limitations for those directors to work elsewhere, to have shares in other businesses, to have various restricted covenants. So if the relationship does break down, you know exactly what you're limited in doing with another company. And also IP is a big one with directors' agreements. So in intellectual property, how you protect that IP is also very important that you cover with directors. The big question is, as a director and employee, and again, you go back to that contract test that I've told you about earlier, because directors there's different protection around for directors having significant control. However, if the director is under your control, you're the person making most of the decisions, that director is responding to you, has little control, has a regular pattern of employment, they also are entitled to unfair dismissal rights if you do choose to terminate a director's contract down the line. So do be mindful that they also are subject to the same employment contract test as well. Okay, I've waffled on long enough. So let's move on to the next slide. Oh, sorry, before I did, apologies. The last comment on the right-hand side of the previous slide was a self-employed contract. And in the self-employed contract, a lot of people use self-employed people, particularly in the way we work these days. But most people don't have contracts for self-employed workers. And I always say, well, why not? They're not controlled by you as much as your workers are. You must have contracts for your self-employed people, because they can run off with your IP, they can run off with your property, they can take your trade secrets, they can solicit your staff, your customers. Okay, you can't limit them as much because they're not employed, and the more you put them under control, they then may fall into that employment test. However, you do still need protection for your business with any self-employed people that you are currently employing. So do think about your self-employed people and how you should contract them, because they should receive contracts. Okay, sorry, moving on then. I'm conscious of time, so let's keep going. Right, which contracts? I want to see if you know what this might be. So I've just put a few scenarios down, and I'm going to ask for volunteers now, if you're feeling bold enough to put your hand up and maybe respond to this. Firstly, the first point, if you are going to contract this person, so you want to enhance the skill within your team, and you want to employ 2 engineers indefinitely, so for ongoing, but only on a Monday and a Tuesday when others aren't in on that day. Anyone want to be so bold to answer the question, what type of contract would they use? And if you want to raise your hand, and then we can unmute yourself. Go on, it's not that scary. Go on, have a guess. Somebody have a guess. We've got a hand. Thank you. Yes, please. Is it Customer IQ?
It is. I'm going to have a stab at a part-time contract.
You did. What did you say? Sorry.
Part-time.
Part-time contracts. Thank you. And if I just go to Kelly, because Kelly also raised her hand. What did you think, Kelly? You're currently muted, Kelly. If you raised your hand, what did you think that contract would be? If you unmute yourself. Could somebody unmute Kelly, perhaps?
Hey, Kelly. A request has just come through for you to unmute yourself. Kelly's popped it in the chat, Victoria.
Oh, sorry, beg your pardon. Part-time. Sorry, I just saw that then. Thank you, Kelly. Sorry. No problems, Kelly. So yes, both of you are absolutely correct. You would use a part-time contract. So so that's what you would do there. So thank you. Well done, guys. Okay, so the next question is, you need extra shop assistants to work a few shifts here and there. I've been very vague, clearly, just to make it more tough. Any ideas, if anybody would like to raise their hand and take a stab at that? Yes, we've got, who's that one there? We've got Charlotte Ellis. Charlotte.
Hi, I think I'd probably offer casual on that basis.
Yes, thank you, Charlotte. I would agree with you. Casual is the way forward in that scenario. Was there anybody else I didn't see? Let's just check. Sorry, I've been chatting on and ignoring the chat. Okay, so thank you, Charlotte. So, okay, employing some staff to help with the busy Christmas period, which is looming. Look at the weather outside. It's definitely on its way. How would you do that? Emma, would you like to unmute yourself and tell us what you think?
Fixed term.
Okay, busy Christmas period, fixed term. You could. How long would you fix them for, Emma?
3 to 3 months.
3 months. Okay, good. Any other ideas on that one? The only thing I would say, you're absolutely right, Emma, a 3-month fixed term contract is perfect. But if you wanted to be a little bit more brutal, can I use that word? You could offer a 0 hours. And therefore, if an employee or a worker, you wanted them to always say yes to that offer of work, you are then more likely to have them turn up to those busy periods. So often 0 hours are used for backlogs or for busy periods, which is typically why they were introduced as standard contracts. So you could do a 0 hours as well. Okay, and you want to hire a trainer to run some training in January. Any ideas on that? So Charlotte's got a hand up, but let's just see if anybody else would like to be brave and contribute first. Lucy, lovely. What did you think on the training?
Would it be contract for services?
A contract for services, yes. And somebody else had their hand up as well. Who was that? They've run away into the hills. Okay, but yes, you're right. So self-employed, contract for services, somebody that you're using for their speciality to come along, deliver it, and off they go. Thank you. And the last one is you have a critical program or project that requires somebody to lead that for 6 months. Any ideas on this one? Charlotte's very chomping at the bit there. Lovely to see. Any other takers before I go to Charlotte? Okay, Charlotte, tell us all about it.
Well, I think I'd probably go for a fixed term again.
Yeah, I think I'd agree with you on that one for sure. Definitely. So thank you for your contribution, everybody. The essence of this slide is to tell you that you really have to look at what you're trying to achieve when you're considering the contract that you're going to use. Because it's all good and well to go to Mr. Google or Mrs. Google and pull off a lovely contract that they've prepared for free, but not every employment scenario is the same, and there needs to be certain protection around that. So these scenarios may begin like this, but equally these scenarios may change depending on how good or bad that individual is that you're contracting with. So it's really important that you do get the right contract for the scenario you intend. Okay, next slide, please. So we're looking now at changing contracts. And again, this is another sticky area of employment law, which often is done badly. Firstly, an employee may wish to change a contract. And there are certain requirements, statutory requirements that they must have to be able to make change. They must have 26 weeks service. And you as an employer must respond within 3 months to that request. We have forms, etc. There's probably forms under ACAS that you can use to make those selected changes. As an employer listening to an employee request for change, you can decline, but you need to have a valid or reasonable reason, business reason about why you are declining a change of hours potentially, working location, etc. It's usually hours that people want to change, and it's usually around childcare requirements. So you can say no to that request, but you need to think about other requests that you may have received. You need to think about the impact it might have on that particular worker. Are they going to be able to attend work? Are they going to become stressed? Are they going to need time off, etc.? Which I totally accept as an employer. It's not your issue, but it's nice to be understanding about someone's situation. But you can decline and give valid reasons why you are unable at that time to make that particular change. You've also got issues around discrimination. It's a tough area of employment, but if somebody says, I need to make a change because of my childcare arrangements have fallen through, and you say no, and they say, well, it's not fair, it's only because you're now going to treat me harshly because of one of those protected characteristics. You can certainly defend that because it's not the reason you're making the decision, but I've seen many companies be taken to various stages because people use discrimination protected clauses to try to win a scenario. Typically, protected characteristics such as, you know, I'm female, part-time, working as a mum, and they try to use that, which is totally understandable. But as long as you have valid business reasons for making your decisions, then there is no element of discrimination, because that is not the reason you are making the decision, and that's the important point. So yes, that's the first type of change, an employee change. As an employer, you may also be faced with changing contracts. So if we look at the next slide, now an employer may decide to change a contract to look at a location change, perhaps. It may be an hours change. It may be that you're suddenly working weekends. There may be very many reasons why you could be changing a contract. You cannot just make a change to somebody's contract unilaterally without their involvement and discussion, because you would be in breach of that contract. Most contracts would say the amount of time that an employer has to give. Now, if you've got, say, a couple of people only affected by this change, then there is no given time scale for a couple of people. But if you're talking about 20 employees or more, then you do have to provide a certain amount of time to make the change. And that time is 30 days for that number of people. If you're looking to change 100 or more employees' contracts, then you're looking at 90 days. So there are various statutory timescales depending on your situation. So let's say most of you here probably don't employ 100 people. You employ, I don't know, 50 people, 30 people, and you want to change one section of your workforce to now work on Saturdays. So you've got, say, 5 people who you now need to alternate and work on a Saturday. What do you do? How do you make that change? So the most important thing is to provide meaningful consultation. Now, what meaningful means is very different from person to person, but it means giving enough notice to present the change, the reasons, the valid business reasons why you need to make that change, and listen to employees, understand their concerns, discuss, respond one-to-ones, and have a good, interaction with employees to try and help them understand why you're making the change. Usually when I'm dealing with these types of situations, I say to the employer, does the employee truly understand why you're making the change? Because that will go a long way to help gain acceptance. Follow your contracts. If your contract says you need to give 30 days, you must give 30 days. If it says nothing, you have more freedom to make that time scale. If you've got any TUs involved, inform those representatives, and ideally get agreement and issue contracts and sign. Now, you may not get agreements. You may have to compromise. You may have to dangle a few extra days holiday or something else like that to get agreement for this particular change. Worst case scenario is fire and rehire. You have to terminate one contract and rehire on a new contract. You are entering in very dangerous ground there, because you are potentially facing constructive dismissal and all sorts of unfair dismissal cases. So if you do the first few steps correct and in detail and with enough time, not rushing it, hopefully you will avoid having to go to the final fire and rehire. So that's, again, a tricky area, but it's one that you have to follow the due process. Okay, let's move on quickly. I'm running out of time. GDPR. Remember this horrible word that came into our lives in 2018? We're no longer part of the EU. Does it even apply? Well, we are still governed by data protection, whether it be GDPR or whether it be the Data Protection Act 2018. So it's important that you're following and you're applying data protection principles. I mean, the law is, if you're operating outside of the UK and in the EU, then you are following GDPR, even if you're a UK-based company. But if you're trading or having traffic come onto your website from the EU, then you are needing to follow GDPR still. Having said that, either way, you are bound by data protection. You should have that in your contracts. You are bound to keep all the data that you collect from candidates through to employees secure, safe, and you're bound to report any breaches of any of that data. This is not a GDPR or data protection training course. I can go into it, but I just wanted to stress the fact that it's typically 6 months, the 6 rule, the 6 months keeping a candidate CV, and if you've said no to them, keep it for 6 months and then shred and chuck away. And for employee data, 6 months post termination, I would suggest you keep that data just in case anything were to come back down the line for any potential grievance, just unfair dismissal, discrimination claims down the line. So do keep your data and do keep it secure. You have a contractual necessity under data protection guidelines to keep that information. So again, we can cover that off at another point if anybody wishes to go into it in more detail. So let's just quickly look at the next slide at what you should issue. And I would say, first of all, when you've got somebody starting application form, you're going to gather all this personal data, some of which is very sensitive data, so be mindful of that sensitive data. Some of those things there you would ask, are you allowed to gather? Disabilities, criminal record. So I've got a slide, I'll wait to discuss the next slide, the disabilities and the health questionnaire in a moment. But criminal record, you are legally allowed to ask about any convictions that aren't yet spent, so they haven't done time or served any particular penalties, but you're actually not legally allowed to ask about any unspent or spent convictions, I should say. So unless your job is particularly related to certain areas which are excluded from the legislation, the Rehabilitation Offenders Act, and some of those exclusions are working with children, working with finance and money, law enforcement, those sorts of positions of significant trust. You would then be allowed to ask about any spent criminal records. Sorry, I don't know if I said the right words. You're allowed to ask any that are not yet spent. You're not allowed to ask any that have been spent unless they're excluded under that legislation. And you would be asking also for, when they do join, personal details to be able to pay them, P45, NI, etc. You may do some data analysis on the sensitive data. I think it's particularly useful for employees to gather that data, and certainly if you're a certain size, you have to gather that data legally as well. Okay, let's move on to the next slide, please. I'm going to ask the question, first of all, do candidates have to declare the following health conditions? Hands up if you think somebody has to declare that they have dyslexia. Hands up if you believe they do. Okay, so I don't think there's any hands. That's fine, thank you. What about if somebody has ADHD? Should they have to declare that on an application form? Okay, here's the big one, pregnancy. Do you have to declare if you're pregnant? Okay, what about if you're deaf on an application form? Okay, what about if you have, oh, we had a hand. So we've got Lucy and O'Neill who believe that, which is great. Okay, thank you. What about if you have a back problem? Should you be made to declare this? Okay, a couple of people. IBS, irritable bowel. What about that condition? Should you have to declare that? And if you've suffered depression, do you feel you should declare or be made to declare that? Okay, thank you for your hands, those people who put the hands up. The answer to these questions is very much no. You shouldn't have to tell your employer any health condition that you have. Having said that, there's always a caveat. If the applicant doesn't tell you that they suffer from a particular condition, it is going to be very, very difficult for you as an employer to make any reasonable adjustments. So if you don't know about somebody's dyslexia, and it is significantly going to impact the job, you can't make any adjustments. You certainly can't not hire somebody because of that. You should be making adjustments for these types of conditions. So I would encourage people to declare any health conditions, but you've got to remember that a candidate does not have to tell you. Now, there's been so much case law around this. I'm aware of a client who didn't hire somebody. Actually, I lie. There's two clients in my head. One client didn't hire somebody. It was a legal client, actually. A connection, not a client, this one, who had pink hair and piercings. And this isn't related to health, but they refused to hire this individual because of their appearance. And it was a scenario that was overturned, and consequently the law firm that then did in turn take on this individual managed to tap into a market which was not typically representative of clients from a law firm, and use that as the sort of USP that they represent all walks of life. Equally, a client had somebody who they employed who has a impairment with their legs, and they were in a wheelchair, and they were really concerned because they had a set of stairs. It was a very small office. They had a set of stairs going up from the ground to the top office, and together they worked through that, and they were very open in the interview process and said, look, we have an office that you'll be required to attend upstairs, and for these reasons we would need you to attend upstairs. And the candidate was actually very open-minded and said, look, I'm very good at crawling, and I would be happy, if you're happy, that I crawl up the stairs every day, which again was sort of a bit out there, but they came to a harmonious decision, and that employee, to my knowledge, is still working very much as a very well-regarded employee. So what I'm saying is, you automatically think somebody can't do something because of an impairment, whether it be obvious or something that you can't see. But by being open and honest and supportive as an employer or as a potential employer, there is usually a workaround. But it's an area where people are afraid to go into because it's taboo, it's discrimination potential. But if you work through something like this, you can often get to a win-win scenario. The question has to be had, having said all that, is there an intrinsic function of the role that requires a certain type of person? And if there is something in that role that prevents somebody with a back problem, for instance, if they're up and down a ladder and you say, how is your back problem going to be, how are you going to be able to work with your back problem? Let's try and get to a mutual agreement. And if there is no workaround, then you wouldn't be treated as being an unfair employer if you were trying to find a workaround and there was no solution, because the requirement was to walk up and down the ladder, and the individual with a back problem, it was not going to work. So there are certain situations where you need to question the intrinsic function, and if that particular condition was going to be aggravated, then you would need to have a look at that. You would need to look at your policies around sickness absence, health and safety, and see if there was some sort of solution. Okay, finally, I think just moving on to the next slide, the important thing is, as an employee, you have a duty of care to ensure that you are making the workplace safe for everybody. You can't make those reasonable adjustments if you're not aware of the health issue. You should be approaching any new hire with a win-win scenario that you are open-minded and will take on all abilities, health conditions, but you do need to be aware of them to make those reasonable adjustments.